I beg your pardon?
They are in the Commission's website.
Please continue, Mr. Premhid.
Be that as it may, it can be on the Commission's website, it can be stapled outside the Commission's premises. The point of the matter that I'm making, Commissioner Khumalo, is that parties often ask courts for relief all the time based on what they understand the position to be. And sometimes a court will say to them, as you will well know, yes, you've made out a case, but this operative part of your relief is a bit too narrow or a bit too broad, and we need to include these people and we don't need to include those people, or whatever the case is. So with all due respect, if it's a question of the schedule, we can amend the schedule. Or if it's a question of the Commission making a directive regarding who should be included and who shouldn't be included if the Commission is with me, then that satisfies the issue with all due respect. Because like I said in the debate in the morning, and I think it was with the chair, is that these requests have always been subject to the chair making the appropriate ruling, either accepting and granting the application, or dismissing the application, or granting it but subjecting it to different grounds on the relief, or anything of that kind. So I think with all due respect, it's a little bit difficult for me to answer the way in which the question was put at me in circumstances where it's being positioned potentially that Mr. Carrim is dictating these things. It's Mr. Carrim saying to the Commission, I'm asking you for these things based on what I know at the time that I know it, and I lay myself in the Commission's hands as to make the ultimate determination. So if the accuracy of the schedule is incorrect, we wear that. And we wear that not because we want to keep some people out or some people, we simply don't know. And that's why we come to the Commission and ask for the relief that we do. May I go on to my third topic? And I think, Chair, I'll be done with my protected time relatively soon. May I just take an instruction? Yes, and I'm just being pointed out that the particular paragraphs that Commissioner Khumalo had difficulty with was 3 and 4. I think what I've just addressed is the difficulty with paragraph 4. Regarding the difficulty with paragraph 3, I just would point out that it's not the main statement that was subject to the in-camera, it's the in connection therewith defined as being in the in-camera application. And even if the drafting is not clear enough to make that clear, let me make this clear now on the record. That must obviously be the case, because if the in-camera application that we're arguing now is unsuccessful, then the normal rules apply. But if the in-camera application that we are arguing now is successful, that would be subject to whatever the Commission and the Chair ultimately grants as the relief. And again, I understand that the concern against me might be what it is. I don't think that the idea has ever been that the main statement must be kept away from the relevant Commission staff. It must be kept away from it being an open publication, or as effective as an open publication. That's the contention in the in-camera. And in regard to the Brown-Mokhotsi example that Commissioner Khumalo raised, apart from saying that I don't know whether Mr. Mokhotsi applied for an in-camera hearing or an in-camera hearing and how that would impact fair trial rights, like I said in the morning, part of the Commission's imposition of an in-camera regime would make accommodations, as it must, for these kinds of issues to be ironed out. So that, like we know, for example, in high court proceedings and in all court proceedings, where there is a confidential affidavit filed, sometimes what the court says is it seals that part of the record, and the parties are given a full opportunity to engage each other on the contents of that confidential affidavit. It's just that those exchanges of affidavits are subject to a confidentiality regime. And we don't ask for anything more than that. And in fact, we ask the Commission, if such an in-camera regime is going to be upheld in these circumstances, that that's the kind of consideration that is applied. May I say then on the third topic that I had, which was about the cases that I wanted to deal with, I think these are fairly trite propositions that I'm making from the cases that I've cited. I've given my learned friend notice of those cases and the paragraphs that I'm going to rely on. So I'm not going to ambush her very deliberately. But my learned friend raises her eyebrows at me. But these cases, we say, put forward two propositions. The one proposition is that the state has a positive duty towards citizens to protect them where there is a concern about their rights. That is derived from cases like Carmichael, Carmichael, I apologize, I always say Carmichael, Carmichael, at paragraphs 44 and 45, and the court will be familiar with Carmichael. And then the other case that we rely upon is the SCA case of Van Devenboden, which the commissioners will also be familiar with, and the paragraphs there are 20, 21, and 22. Now, why that's relevant, of course, is because we say that on the facts of this case, there is a threat to the right to life, security, integrity, family, commercial interests of the witness. This is a body that exercises public power in the name of the state, and so this commission is caught by the same obligations that the state has to make sure that where issues of safety are raised, that it properly applies its mind and discharges its power in accordance with that. The other two cases, sorry, I said 4 cases, there's 6 in total, and I'll come to the other 2 shortly. The other 2 cases that I want to refer to is the Constitutional Court matter of independent newspapers, otherwise I think commonly referred to as Masetla, at least that's how I know it. And the paragraphs there, the relevant paragraphs there are 42, 43, 44, 45, 58, 59, 60, and 61. And the other case that I would refer to whilst I'm talking about Masetla is the SABC versus NDPP case that came before the Con Court. And I think that was, I speak subject to correction, but I think that might have been in the context of Van Breda and whether or not his criminal trial could be subject to publication. And the paragraphs we rely on there are 28, 29, 30, and 31. And what those cases make abundantly clear is that courts in those contexts, we say courts, it applies as equally as against this inquiry as a tribunal, must engage in a balancing exercise where default positions of openness, which is what the default rules of this commission envisage, conflict with competing and contesting rights. And where those competing and contesting rights are put before the court, and this relates to what I was saying earlier about one factor in the basket of factors, the court will seriously apply its mind to circumstances where it treats openness by default not as an absolute principle, that there are justifiable circumstances where it will derogate from openness as the default principle, and that those require then the application of this balancing act. And we say that some of those factors that need to be included in the balancing act are those cases, are the instances where my client comes to the commission and under oath tells you about the threats that he's facing to life, limb, property, and family. The other 2 cases, if I may, whilst I'm machining through this list, is MIDI television. I apologize. I think MIDI television, the tribunal will be familiar with at paragraphs 19, 20, and 21. And the other older constitutional court case of Mamabolo, which, if I'm not mistaken, was written by Justice Crickler, and the relevant paragraphs that we rely on there are 41, 42, and 43. And what we say those 2 cases give rise to, again in the context of discussing the openness by default principle, is that firstly, no single interest, this is from Mamabolo, no single interest overrides others. So yes, just because this commission might have an interest in an open justice style of argument, that justice must be seen to be done, does not mean that that is judged in isolation from competing interests where security of the person is concerned and so on. The second proposition that these cases give rise to, which is from the MIDI television case, is that the restrictions on publication are permissible where it's demonstrable that there is substantial risk to justice or to other constitutional interests. And we say that we fall into that category. We fall into the category that there is substantial risk to constitutional interests, and that's why the in-camera application, in the way that it is brought before you, is entirely justified. Chair, on the last topic, if I may, the topic of prejudice, I did address some of this prejudice in the morning at the so-called prejudice being at the hands of the Commission, and I'm not going to repeat myself there. Instead, all I'm going to say, Chair, and you will recognize this not only from having deposed to the answering affidavit in the unsuccessful urgent application, but also when we were in front of you in the postponement application, that my client's complaint throughout his involvement in this Commission's proceedings is one about consistency, fairness, and procedural and substantive rights. Rightfully or wrongfully, that's his view, that he is being treated in a way that is prejudicial by the Commission, and in fact, what is happening is rather than the Commission seeking to cooperate with him and his reasonable requests, like, for example, receiving the proper 10-6 notice, like, for example, receiving the bundle in good time, like, for example, receiving an undertaking regarding the confidentiality of the statement in good time, like, for example, that an expedited application which is sought to be determined before a deadline is approaching is placed before the Commission, doesn't seem to happen. Those are the head notes, if I can use that phrase, of what my client claims as his ongoing prejudice in these proceedings. And I mention that prejudice because it's regrettable that we find ourselves in this position. Unfortunately, the way in which my client seems to be treated is in an adversarial manner rather than what we understand a role of a commission of inquiry to be, as being an inquisitorial manner. And unfortunately, the way in which things have unfolded in front of this commission have meant that, I apologize, someone is trying to phone me again. The difficulty that my client has is that rather than reasonably being accommodated so that he can come to the commission and give the evidence and do his inverted commas job and get out of the commission as soon as that job is done, instead we get tied up in these kinds of procedural skirmishes where at the end of the day, like for example on the issue of the bundle, which was the subject of the postponement application, the bundle eventually was given, a specific bundle was eventually given the night before we were expected to appear for the first time. And why I highlight that prejudice in the context of this ongoing dispute we have in front of you is that in the absence of any credible basis to say that these threats are not real and not serious, we would say, and I say this in a guarded manner, that it's heavy-handed of the Commission, with all due respect, to oppose the application on the basis that, it's already been publicized or whatever else it is they say. Because at the end of the day, if the in-camera application is granted, this commission will still be able to do its job. And it's important to say that because the in-camera application at various times is treated as though it's an act of gamesmanship, which it isn't. It's a legitimate request under the Commission's rules for protection from the Commission regarding the giving of that evidence so that my client can do what my client needs to do because this Commission has asked him to do it. All we would say is that when this Commission brings my client in front of it to give such evidence, that it does so in a manner that is suitably sensitive to the threats that he faces and gives appropriate relief to protect him in light of those threats. Might I take an instruction? Just before I yield the floor, so to speak, just one thing that we are aware of. Obviously, whilst we sit here, we expect the Commission's supplementary bundle, which we anticipate to be given today, because it's 2 business days later after the filing of the statement. We hope that that will be done, because that will again help my client come and do his job, rather than end up in another procedural skirmish about whether or not there's been adequate time or inadequate time. But Chair, those are my remarks in my protected time, and I yield. Thank you.
Thank you, Mr. Premhid. Just on the last point, Ms. Hassim, I assume that if that bundle is not ready, you will move mountains for it to be served today.
The bundle will be provided today.
Thank you. Thank you. Mr. Premhid, you, quite early on, you made maybe let me start right at the end. I'm not sure that I follow your submission on the relevance of what you refer to as head notes on prejudice to the determination of the in-camera application. I'm not sure what the relevance of those head notes is exactly. You did explain it, but I still remain in the dark as to what you suggest the relevance is.
May I respond? Thank you, Chair. No, I accept what you say to me. What I am using those particular examples of is, in each instance of those examples, my client has asked for a reasonable accommodation, which has been refused. The response to that has then been that my client has to, through its legal representatives, litigate quite aggressively, whether in court or in front of the Commission, with interlocutory applications, to have that reasonable request, firstly, reasonably considered and then decided. And I was linking that pattern of conduct to the opposition that is being put up here, and I explicitly detailed those grounds of opposition, the publicity, the fact that it's already known, but importantly, there's no counter-argument as to the credibility of the threats, that in those circumstances, the Commission insisting that my client be made to give the evidence in an open session where those threats are highlighted for determination is a further instance of the prejudice that my client finds himself in. That's the extent I was using it.
I trust, though, that the suggestion is not that the in-camera application will not be decided on its merits.
No, not at all. I know for a fact it will be decided on its merits.
I just wanted to be sure in my mind what exactly you mean by that.
In fact, Chair, if I may, I think the way you've put it to me crystallizes the exact point. It's that in each of those instances that I've spoken about, my client, to use your phrase, has had to move mountains to try and clarify his position and get certainty and outcome. And this in-camera application is yet another example of that, in circumstances where my client not only said on the 18th, a week before, he asked for an outcome by the 25th, bearing in mind that the 27th was the due date. He also said, just determine this on the papers expeditiously, so we don't have to take up the Commission's time and I know what I need to do. So I fully agree with you, Chair. It must be decided on the merits, but the fact that we've had to repeatedly move mountains to get that determination, and even in circumstances when we asked for an earlier ruling, is the exact prejudice that my client relies upon. Thank you, Chair. I'm indebted.
Thank you. Now, let me take you to something you said quite early on, which is, and I hope I will not mischaracterize what you said. You said that applications for in-camera hearings, or rather this application for an in-camera hearing does not hinge on the evidence Mr. Carrim is going to give. Even though I cannot think of ready examples, I'm willing to accept that that may be so in some applications. But what exactly do you say is the basis for your submission in this particular application? I'm asking that in this context. Not every and any witness that has testified before us has received threats. And those that have either received threats or had a reasonable basis to believe that their lives were at risk, even if they had not received threats, gave us cogent reasons for us to understand why there would have been threats and why there would have been a reasonable belief that there was a risk of bodily harm or even a risk of them being killed. Something cogent was placed before us. Please bear in mind that here, I'm not talking about just the fact of threats. I'm talking about what underlies the threats that we are told about. That's where my focus is. Now, on what basis would Mr. Carrim, I know the threats don't come from him, and he says in so many words in his affidavit that he does not know where the threats come from. But if he sits down and applies his mind in the light of the testimony that he's going to give, who does he think may possibly be threatening him? He is best placed to think about that and possibly to even come up with answers to that. Bear in mind that I say in all without exception, all the other cases where applications for in-camera hearings have been made, we were given something cogent, which had a factual foundation.
Thank you, Chair. May I respond? Chair, on the first point, where you said, you put to me the not hinged proposition, and you said it may be so. Just to emphasize that, our position is that based on the Commission's rules, that doesn't seem to be the case to us. But let's leave what the rules may say or not say to one side for the moment. The not hinged proposition comes from the fact, like I just read back to you in Mamabolo, it's a weighing up exercise. And so in...
I'm not there yet. I am not at Mamabolo in that weighing up exercise, because you raised the weighing up exercise in the context of open justice. So I'm not there yet. I'm just at the level of possible facts, the possible basis for threats.
I'll come to that last.
That's where I am.
I'll come to that
don't
last.
quite see how the Mamabolo balancing exercise, the open justice principle,
Yes.
I just don't see
May I
how
develop the submission?
how the relevance of that is to what I'm raising.
May I develop the submission?
Yes,
And I will come
yes,
to those very
yes.
point about the facts that you put to me. I'm sorry if I'm taking the circuitous route. The reason that I start at Mamabolo is because it speaks to the court's discretion in weighing up issues in front of it when there is a counter consideration to the default position of open justice. So insofar as where I anchor my submission, that it's not exclusively contingent on the content of the main witness statement, is derived from the Mamabolo principle, buttressed by the MIDI television principle that talks about we derogate or we depart from open justice when there are credible threats and so on. So I'm willing to accept.
I'm exactly at the credible threats.
Yes, I'm coming.
I think that's where we should
Yes.
be before we get to the balancing exercise. Show me the... I'm just asking you a question, and I'm not suggesting that the threats are not credible.
And I'm not
All I'm
suggesting
saying
that either.
is, what is the possible grounding? And that will then help us
Sure.
determine the question of the credibility
No.
of the existence of the threats.
I-
That's where I am.
I accept that.
Yes,
I accept
yes,
that. But I think what's important is where I started out, because that sets the ground rules with respect as to what discretion the court is being asked, or I apologize, I keep saying court. I look at you, ADCJ Madlanga, and I go back to a different time and different place. But Chair, it's about what discretion this inquiry tribunal is being asked to exercise. And that's why I start with both Mama Bolo and MIDI Television, because it says that, yes, you consider openness, but you consider all the things on the other side of the T account, if I can use that phrase. Then let's go to the examples that you gave me. This is now the facts and the credibility that you were talking about. Those examples, from my understanding of what you have said, Chair, is that they were all anticipatory explanations for why in-camera hearings should be justified, because if I get your words wrong, Chair, please correct me, but you said something to the effect that those witnesses who asked for in-camera hearings gave cogent reasons for us to understand who would have threatened them or where those threats could have come from, in anticipation of asking for in-camera.